and didn't make it 50 days from being released from that before he's back in police custody on these felonies.
Well, you're not concentrating on behalf of Mr. Floyd, who I believe is attending via Zoom.
State your name, please.
Floyd.
This is People's Motion.
Yes, Your Honor. Thank you so much for setting this very quickly so that people can hear. I know the court has reviewed the motion. I'd like to start with a couple of housekeeping matters.
Yes.
Record, I know Ms. Preacher got appointed this morning. So I had an extra paper copy of the police report that I gave her in court this morning, but I know that she hasn't had the benefit of reviewing a lot of the discovery in the case. So I just wanted to put that on the record. And mostly, Your Honor, we're here today asking the court to reconsider the bond. In my written motion, I did indicate that the defendant is charged with a variety of extremely serious offenses, including but not limited to armed robbery, carjacking, assault with intent to rob, armed larceny from a person, so on and so forth. My understanding is that the defendant is currently on juvenile probation related to a CHP. He has been not compliant with that probation, most recently being put back into detention in February and released back out to his mother in March. And in this case, he was in Ann Arbor after midnight with one other individual at the time of the armed robbery, but with a group of other individual times later than the armed robbery, a group of 4 juveniles and 1 adult, ultimately an entirety of 5 people. I do believe that the likelihood of conviction is extremely high in this case, as this armed robbery and carjacking was captured on video from the Bell Tower Hotel. Very concerned for the safety of the community, mostly a bit concerned about the defendant's ability to comply with court orders, given his probation and non-compliance there. People do recognize the defendant is extremely young and will turn 18 later this month. But we do believe that the PR with the home confinement tether is an abuse of discretion. We'd ask the court to revisit the issue of bond. Happy to answer any questions the court has. Thank you, Your Honor.
All right. Richard, I realized we were notified that you were being appointed to the case last night, but I don't know. Are you prepared to address the issue of bond at this time? Or?
I am, Your Honor, for the
All right.
following reasons. First of all, the standard, we all know what the standard is. Okay, so and then I did have an opportunity to speak to my client's mother and my client. So we are ready to prepare.
Go ahead.
Okay, so you'll understand that the standard here, I'm sorry, I didn't ask my arguer at the table.
That's right.
Okay, thank you. Abuse of discretion. And that is abuse of discretion happens when it is manifestly unreasonable, arbitrary, or based on a clear error of law or fact, rather than merely being a decision an appellate entity such as yourself would have made differently. The standard recognizes that the magistrate had firsthand knowledge of the case, including arguments made by both sides of.
Before you go on with that, understand that, as is customary for me with these motions, I have reviewed both the swear to video as well as the arraignment video. So okay. I am very well aware of what the magistrate was seeing, but you may go ahead with your.
All right, then I'll skip that. Okay, so it's my opinion that based on it, the magistrate was in the best position. He had all the facts to make a decision. I understand the seriousness of what the crime here and the seriousness of the accusations and allegations that Ms. Feltes brought up. My client here in the courtroom, his mother is here. He has family support. I've spoken with his mother and she is willing to allow him to come back into her home.
How do I reconcile all of that with the fact that this defendant now faces 3 life offenses, was on probation for a CSC 3rd, did not comply with that probation, was basically detained in the detention center by Judge Conlon for a period of about 30 days plus, and didn't make it 50 days from being released from that before he's back in police custody on these felonies?
Well, you reconcile it this way, Your Honor, because, it's a tough question to answer, but I want to do my best, okay? You reconcile it because he, in speaking to his mother and speaking to him, he understands the seriousness of this, and that's how you reconcile it. I mean, I get where the court's coming from, but this motion has to be, addressed. And, I appreciate the court listening to my arguments, but I think that there's other ways to ensure public safety, and that.
How do I not consider it an abuse of discretion where the co-defendant, as I'm to understand from the swear to, was standing between the victim in this case and the vehicle in a position that it's believed was going to stop the person from going to the vehicle, that this defendant actually pointed a pistol at the person, then struck the person with that handgun and took the phone. And this defendant did all of that. He has a PR. The other defendant who was standing there equally is liable for what's going on. But that person gets $100,000 cash surety bond. None of this, I'll be honest with you, and again, I'll listen to you, but I'm telling you from where I'm starting, none of this makes any sense to me.
Well, I can appreciate the court's candor. The court's going to make their decision, and that's the court's prerogative to find an abuse of discretion. I mean, I don't have information as a swear to. I don't have the $100,000 bond that was set on the co-defendant. All I can say is that I believe it was Magistrate Odatello made that call, and he had the information. He had all of this information, I presume, because I haven't seen that video. I'm assuming, and maybe I'm incorrect in assuming, but he made that decision based on the information that they have. Now we're here, and if the court feels it's an abuse of discretion, it's within its power to do so. I'm saying that if the court is, just apply the standard that I rattled off earlier. My client has family support. My client, I've had a conversation with him. He understands that whatever court order said is followed. If he's able to post bond and release on bond, then that he has to follow his court orders. The family is suffering through financial hardship. In the home, it's a single mother home. There are 5 children, including my client, so there's 4 still at home, and she is the sole provider. So I'd ask the court to consider that when assessing bond, that the family high bond would be financial hardship, and if possible, allow him to have a 10% privilege run. Thank you.
Ms. Feltus.
Because it is my birth, Your Honor, I just have a couple of more things I'd like to point out for the court. I want to make sure it's very clear. This firearm was a BB gun, it was a pneumatic gun, but it is incredibly realistic looking. I would ask if I've shown this to Ms. Kracher, if the court would consider looking at a photo of this to see how realistic this looks. I do think it's important when we talk about this to realize that. If there's no objection from defense.
No objection.
It's not labeled or anything, Your Honor, and I'm not admitting it, but I just want the court to see the firearm that was recovered. I didn't say the weapon. I didn't say firearm. I should say weapon. In my experience, this looks like a Glock, Your Honor, and honestly, it is amazing to me how realistic it is. There's no orange chip. It's completely black, the dark gray black. And the last thing that I will just let the court know. What I've already covered. I'll rest on everything I've already said. Thank you, Your Honor.
Anything else, Ms. Kirk?
Just what I already said before, especially about the financial hardship of any high bond would produce on the family, Your Honor. Thank you.
The court, upon receiving the people's motion, they've indicated, read the motion, reviewed the swear to, I also reviewed the arraignment so that I could fully understand what information the magistrate may have had at the time that the decision was made. I tried to give deference to the magistrate's decision regarding this. I will be quite frank with you, it is impossible for this court to do that in this case. The bond as set in this case, with all due respect to the magistrate, it's illogical to me. It makes no sense. I have someone, as I previously indicated, who is on or under sentence on a CSC 3, has not complied with the conditions of that probation. How would I even believe that that individual would comply with just conditions on bond on a capital case times 3? It doesn't make any sense to me. Further, that there is an indication, and I'm not sure why this was not taken into account. There is an indication that this might be a ring of individuals involved, some of them juveniles, and so that this not only is some isolated incident, but that this defendant may be involved in effectively a criminal enterprise that clearly would jeopardize and pose a risk to the community at large. I think it's, and it pains me to say this, that this bond virtually is illegal because, first of all, he's on bond and commits these offenses. Secondly, at the swear to, it was very clear that all of the elements necessary given this charge, all of the elements there regarding the presumption or of guilt or the likelihood of conviction were there, that quite frankly, I'm not sure why his bond was not denied. We don't, in a lot of cases, get to see that, or certainly not at the arraignment stage, wouldn't be able to make that finding that this likelihood of conviction is there. This one is very clear. He's caught on video. The specific question was asked by the magistrate regarding identification of these individuals, and the officer in charge was able to, or the officer swearing it out, was able to articulate specific things that pointed to this defendant and his cohort as the people that did this. I'm not making a finding of guilt, but I certainly, on that low standard for the purposes of bond, I don't know how one gets past it, frankly. Was there something you wanted to say, Ms.?
I wanted the record to be clear to Your Honor, because the type of probation the defendant was on was juvenile probation and on adult probation for a violent felony. It wasn't immediately clear to me when I filled out the bond form if I had a reasonable basis to ask for bond to be denied pursuant to that provision of the court rule. And frankly, Your Honor, and I apologize, I didn't have time to do the research to get it done. And I wanted to ask the court for what I knew I had an ethical way to ask for, which is why we did not request that bond denied for a violent felony, because frankly, I wasn't sure if juvenile probation and violent felony was going to work in the same way that adult probation for a violent felony would work for the purposes of bond. And I wanted the record to be clear about that people did consider that he was a juvenile that was on juvenile supervision probation as opposed to an adult, just so that we're very clear that that wasn't going to be thought about. But I did have time to do the research before getting it in.
I looked myself, and I don't know that I saw anything definitive. I mean, the cold-hearted reality is that it was, I mean, when one looks at the purpose of the rule, It's that the person is under court supervision and monitored, and then this happens.
Thank you, Your Honor.
And so, yeah, I think I have stated everything I have stated on the record. I also will indicate I am not, well, I don't judge a bond based upon other bonds that are set. There is a bizarre discrepancy between the two individuals involved in this offense. And clearly, based upon what is being said, this defendant was much more clearly involved with the activities of violence and harm toward the victim in this case. For those reasons, and having reviewed everything that I have, I regrettably but don't have any other option but to say that the setting of a personal recognizance bond in this matter, given these charges, given what I know about the case, and having reviewed everything, is a clear abuse of discretion. The court will vacate that and will reset the defendant's bond. I will leave the conditions that were set by the magistrate in place, but in terms of the monetary amount, I will reset the bond in an amount of $500,000 cash surety.
Before we consider 18%, Your Honor.
I will not, and mainly also because I don't know that the defendant being on probation violating this, my opinion is he's not entitled to it. And I'm certainly not going to exercise my discretion to grant.
Thank you, Your Honor, for considering that. Just had to ask. No, thank you.
Thank you, Your Honor. I will also let the court know to schedule for probable cause conference in 6 days.
Yes.
And discovery continues in this case and the investigation continues. And I do believe that we may have additional information by the time for the probable cause conference where the people may wish to revisit bond and our proofs become even stronger to request that bond be denied entirely. I do think that's a possibility in this case, but I don't know it for sure.
Understood. All right. Anything additional?
The people.
All right. Thank you. The other, in my understanding of how this works, he sat on the 28th.
That
That's
is my
correct.
understanding, yes.
Yeah, that's correct.
And he is going to be transferred to our jail on the 29th.
Yes, correct.
So I don't know if you're aware of that, Ms. Craig.
I appreciate that, Your Honor.
All right. So see everybody on the 28th. Then.
May counsel and approach.
You may.
So, thank you.
On this thing.
I don't know, maybe her aunt drove her here, decided to leave the car here and walk home and leave the car here for 2 days.
She got caught by a train and now she's on some road, I don't know, but she shouldn't be walking.
People Against Summer, Lori Greathouse, 25F245-336. Your name, ma'am?
Summer Greathouse.
Mr. Longton, your appearance? I need to read you both something that was handed me today. And I'm not trying to create any more problems here. For her and her ex-husband or estranged husband. But I need to read this to you because I'm not going to conceal anything, obviously. He just says to whom it may concern. Who am I hearing right now, Heather? Can you tell me?
I believe it's the jail background noise.
Okay, I'll keep my voice up nice and loud. I am writing to you as the sole legal property owner of the residence located at 30,001 Huron Meadows Drive, Rockwood, Michigan, 48173. I'm aware that the defendant, Summer Greathouse, is currently serving a jail sentence under your jurisdiction and has an upcoming court hearing. Please be formally advised of the following. One, no consent for tether/ankle monitor location. I do not consent to my property being used as a designated residence, base station location, or monitoring site for any court-ordered electronic tether, scram device, GPS tracker, or house arrest equipment. Two, revocation of residency effective immediately. Summer Great House does not have permission to reside at, enter, or visit my property. Her residency privileges have been fully and permanently revoked. Formal eviction papers are currently being processed. Safety and security, that's number three. For safety and privacy reasons, she will be barred from the premises immediately upon her release from the Wayne County Jail. Four, clarification of child custody, rebuke of fraudulent claims. I am aware of the defendant's history of perjury and manipulation before this court. Specifically during her prior bond violation hearing, I'm advised she may attempt to claim her immediate release is necessary for childcare. The children are completely safe, stable, and cared for in my custody. Her claims of childcare hardship are entirely false. Because an alternative housing plan will be required for probation or tether compliance, I am notifying the court and the probation department in advance of her hearing so that her defense counsel, Mr. Longton, can arrange an alternative location such as a residential facility, shelter, or different address that does not involve my property. Thank you for your immediate attention to this matter and for ensuring this notice is placed directly in her official case file, respectively submitted, Harrison Steves. So with that,
I respond to that.
you can respond whatever you want.
Because there's a lot of falsehoods in there.
Hang on a second, hang on. You asked for a hearing, you filed a motion. I don't quite understand this. Let's go quite forth on it. That the court opined on the record that defendant had violated her bond provisions by working in a restaurant that serves alcohol and not informing her probation officer about that employment. I had to go back and listen to the tape. I didn't say one word about that. What I did say is she wasn't truthful with me. What I did say is that when I asked if there was any material additions, corrections, or deletions, she should have been forthcoming. She should have been forthcoming with her probation officer. That's the only reason I scheduled this emergency motion for reconsideration of sentence, because that's just not true. I didn't say anything about bond conditions. I said she violated bond conditions in the past. She lied to me under oath in the first time she was drinking. She had 26 late sober link blows. She was positive for alcohol back in February 4 or 5 days in a row, 6, 7, 8, 9, and 10, I think it was, or February 8, 9, 10, and 11. And by the way, just to pile on here, she had to drive to court because somehow, some way, a car titled in her aunt's name remained in the parking lot for 2 days after she was sentenced. And by the way, I haven't checked it, but I believe she was still revoked. And this has been the pattern with your client. So you can correct whatever you want. I'm going to listen to you, and then we'll go from there. What do you want to correct?
She is a lawful resident.
That's fine. I'm not the divorce judge.
But what he's done. Trying to take custody away from her. He's grabbed the kids, he's changed the locks. She's a lawful resident of that house. That address is on her driver's license. She has the right to go there. Please enter that house.
I just read you into the record. What he said. I didn't say anything was truthful.
Yeah, that's correct, John. You did not. But I wanted to make that clarification. But I know my client is dying for me to address what you read in the record of that letter.
Okay, good enough. What else?
So what's happened is what I feared was going to happen. He's hired a new attorney. He's going to try to take custody away from her with an expiring order because she's in jail. I have no defense to that as long as she's incarcerated. And she's been the primary custodian of this children since birth. The biological father, the never married mother, has not been a primary caregiver, not been the cause. He's seized on this. Then we grab custody, and I think the children are going to be harmed if we continue to keep her incarcerated. I have no doubt.
Is that you, Mr. Steves? Are you Mr. Steves?
Yes,
Okay, he's in the back. Go ahead.
I have no doubt that these children are being harmed by taking away.
I'm not, but I don't have anything to do with it.
I know you must, but you certainly have a jailhouse that you can care to by her own. That's what I'm asking. She has learned her lesson. There's no doubt in my mind, she has learned her lesson all about honesty with this court and fucker.
Can't lie to the court.
Your Honor,
I will not go through a sobriety court with a defendant who's lying to me left and right. And I gotta tell you, I don't know, maybe her aunt drove her here, decided to leave the car here and walk home and leave the car here for 2 days.
I tell that. And you tell me.
Your Honor,
It just underscores how she has not taken this seriously. Listen, I wanted to give you this hearing only because I wanted to clear up this record. I did not say anything about bond conditions. That is not a true statement, Mr. Longton. What I did say is she was not honest. I will let you speak for 10 seconds, ma'am, but you've got a lawyer representing you. This is a motion hearing. If you want to say something, you can, but go ahead.
Your Honor, when you asked me about the employment, I brought it up. I was unsure about bringing it up before that. I was desperate to just work for my kids. My kid's dad does travel a lot for work. I'm a mom. I wasn't sure what to say. You know, I wanted to bring it up. It wasn't something that was permanent. I want to complete this program. I want to be there for my kids. I enrolled myself in school. I've been going to counseling by myself. I understand that I made mistakes in the beginning, but I am more than committed and willing to complete this program. If you would please just consider it. I'm a mom. I want to be there for my kids. I want to put this all behind me.
No, but you can't just say I can commit all these crimes and then say I want to put it behind me.
I will
This is
not.
the thing. This isn't a simple isolated mistake. You've got 4. You lied to me under oath about your alcohol use. It's too much. I will not spend the twilight years of my career trying to get people through sobriety court who are not being honest with me. I will not do that. I'm sorry.
Will
The
not
motion
have
for
a
reconsideration of the sentence is denied. I wish you well. I hope everything works out for you and your family. I really do, Ms. Greathouse, but I'm not changing my mind. Thank you all. Have a good day. But are you ready on Shores Financial? Mr. Runyon, you ready?
Yes, I'm ready, Your Honor.
I feel sorry for Ms. Ratliff and you. Shores Financial versus Scott Ratliff, 21F1466. All right, how you doing, Mr. Runyon? Your appearance again?
Thank you. Your name, sir?
Justin Heaton.
And sir, you were intending on representing yourself?
Yes.
Pardon?
Yes.
All right. I do have to advise you that a couple of things. First of all, there is some danger in representing yourself. You'll be held by the same standards as an attorney in courtroom. The court is not here to assist you in that manner. I will presume that you would know the court rules and the manner and procedures. You understand that, sir?
Yes, Your Honor.
All right. I do also have to advise you that you're here on 2 counts of assaulting, resisting, or obstructing a first responder or police officer. You understand that, sir?
Yes.
Both of those are felonies punishable by up to 2 years incarceration, a $2,000 fine plus court costs. You understand that?
Okay.
Right. If at any time during this procedure you wish to be represented by an attorney, all you have to do is ask the court, and the court will be more than happy to make sure that you are afforded counsel. You understand that?
Yes.
Do you still wish to proceed on your own? All right. What would you like to do in this matter?
Well, I was hoping to see if you were able to remove me from the jail today.
You're asking me to reduce your bond?
Yes.
Well, even before I get there, I have to do something with the case. What would you like for me to do with the case, sir?
Well, seeing as I was hoping to be removed from the jail so that I could better prepare for the case, that was my best wishes.
You don't know what procedure comes next in this process, do you?
I assumed it was on the court. Yes.
Pardon?
I assumed it was on the court, to decide that, yes.
On the court,
To decide the next procedure.
sir, do you want to be represented by an attorney? If for no other reason than to assist you in this matter, I have some serious concerns that you're not sure what you're doing. And I'm not saying that in a bad way. I just don't think you know what you're doing.
Okay,
Okay, what?
no, thank you.
Okay.
I thought that I stated my claim fairly standardly.
Do you want a preliminary examination in this matter?
I was just speaking to, my best wishes.
The next thing that will happen is the preliminary examination when the case is ready to go. Are you ready to have your preliminary examination?
Proceed,
Pardon?
proceed.
Proceed. What's that mean?
I'm ready to proceed.
You're ready? Have you seen the discovery in the case?
The only paperwork I have is right here. It's the,
Your Honor, our office has not really been able to deliver discovery. We would be asking for at least one of the journals to make sure Mr. Heaton has studied. Right.
Understand that, sir? You haven't seen the paperwork in the case, right?
this is the paperwork that I did request, proper paperwork before today, yes.
You requested it from whom?
From the jail upon,
From who? All right, sir, you haven't seen a police report or anything like that, right? So you don't know the particulars of the allegations of the charges here. That was a question. You don't understand that, correct?
I would just not like to answer.
Would you like a copy of the police report?
Before we proceed with the case today,
At any point. Sir, I'm going to ask you again. Do you wish to be represented by an attorney?
no.
All right. What I'm going to do, however, is I'm going to, out of fairness, grant the request of the people to adjourn this matter. How long will it take the people to get paperwork to him so that he can be as prepared as he would like to be to proceed to exam?
We will get that over as soon as we can. My understanding, there are also videos that may take a little bit. We'll find the one.
Well, I'll give you two because they're going to have to arrange a way for him to look at it. And I don't. Probable cause conference, court's going to find good cause to do so. I'm going to adjourn that to June 4th, 2026, 9 a.m. On in this matter will continue. Thank you. So that we're clear, I'm denying the request to release the defendant at this time.
The judge has made his decision. He vacates the personal recognizance bond and resets the monetary amount at $500,000 cash. He also notes that he's not granting a 10% privilege, meaning the defendant can't post 10% of the bond to get out. He has to come up with the full $500,000. The judge says, in my opinion, he's not entitled to it, and I'm certainly not going to exercise my discretion to grant it. The defense asks if the judge considered the family's financial hardship, but the judge's decision stands. The defendant, just 17 years old, is now facing 3 life offenses with a $500,000 cash bond. He'll be transferred to the adult jail, and a probable cause conference is set for 6 days out. The message is clear. When you commit violent felonies while on probation, the court will not show leniency. This case is a sobering reminder that actions have consequences, and the younger you start, the harder the fall. If you found this case as compelling as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.